So thank you so much for that introduction, and dear ladies and gentlemen, my name is Lilla Garayová. I am from Bratislava, from the Pan-European University and Faculty of Law, and I also am a researcher in the Central European Professors Network. It is such a pleasure being here, and I really wanted to thank the organizers for the invitation, because it is always a pleasure being here, and especially when with so many wonderful speakers. So thank you so much. So today I'm going to talk about the right to family life under the European Convention on Human Rights, with special regard to Central Europe, of course. So let's see. I do think I managed my technical issue, but if not, feel free to remind me of the time here. So this is a huge topic, of course, talking about the right to family life under the convention. And of course, 20 minutes are definitely not enough. And with that, I'm not saying that I'm going to exceed the 20 minutes. I'm just saying that, of course, these are going to be a few ideas, but by no means it is a comprehensive review of the right to family life, which I did attempt to include in a written study that will be published in the conference papers. So I do invite you to read that if you wish to learn a little bit more or read a little bit more thorough analysis of the case law and the interpretation of this right. So with that, let's start. The protection of the family dates back to the beginning of mankind, essentially to prehistoric times, and the toolbox of family protection originates in the natural laws that long preceded the state and the law itself. So the protection of the family is one of the oldest natural and moral laws. You know, self-defense, the protection of children, family protection, the protection of communities are all manifestations of one of the most basic human instinct that we have, and that is the survival instinct in the biological sense. So based on this, humans, like any other living organism, in general, thrive to survive, and in order to survive, they must reproduce their inherited genes so that their parents, in a sense, can continue in the lives of their offsprings and the descendants of their offsprings, and so on. So that is the reason a person establishes a relationship, a heterosexual relationship, and starts a family and tries to create a security and protection for that family. So all of this sounds quite natural because it is, and it is evident in itself. So we shouldn't even have to question it. So this would be true, of course, if marriage and family worked hand in hand with the natural law as we know it. However, as it appears, modern marriage and family are no longer working the way they once did. And, you know, some might say that these institutions are even in a crisis in the Western civilization. Therefore, we need to have a legal framework, a legal protection to protect families and the right to family life. So the legal framework in which the right to family life and family unity is based is contained in numerous human rights documents and instruments, in international human rights law, in international humanitarian law, in international refugee law, and so on. And as a foundation or as a common ground between all of these documents, what we can say is that there's a consensus that family is the fundamental unit of society. And the family is therefore entitled to respect and protection. A right to family unity is inherent in recognizing the family as a group unit, because if members of the family did not have the right to live together, to exist together as a family unit, there would not be a group to respect or protect. So the right to family life, as I mentioned, exists in many international human rights documents, which a few of them you can see on the screen. And it is set out in international human rights law, and therefore it is applicable to everyone, including refugees, including asylum seekers and others in need of international protection. So under international human rights law, the family is recognized as a fundamental group unit of society in the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, but also in the International Convention on the Protection of the Rights of the Migrant Workers and members of their families, contains a very similar language, as does the preamble of the 1989 Convention on the Rights of the Child, and the 2006 Convention on the Rights of the Persons with Disabilities. So this is not a unique right that we have in the Convention. We see it throughout all of these international human rights documents. We see, for example, the right to marry and found a family in Article 16 of the Universal Declaration of Human Rights, or in Article 23 of the ICCPR, which also adds that it is a right that applies to persons of marriageable age and only with their full and free consent. So this right we see being manifested in a multitude of human rights instruments. A very important set of rights connected to it is, of course, the rights of the child, and the CRC sets out some of the strongest protections of the child's right to family life, as well as the state parties' corresponding obligations. For example, in Article 7, it accords that, as far as possible, the child has the right to know and be cared for by his or her parents. And at the same time, in Article 8 and 9, it says that states have the responsibility to undertake to respect the right of the child to family relations as recognized by the law without unlawful interference. So this principle, also a principle of the best interest of the child, that is in the CRC in Article 3, is an overarching human rights principle that, of course, encompasses the right to family life as well. And in Article 3 of the CRC, it requires states to ensure that in all actions concerning children, the best interest of the child shall be the primary consideration. So this applies to all children without discrimination, and the Committee on the Rights of the Child views this principle as a threefold concept that encompasses the substantive right of the child, and also an interpretive legal principle, and also a procedural right. Now, all of these international all of these principles and laws in international law are also mirrored in regional human rights provisions. So the family is the fundamental group unit also in these regional human rights instruments. And if we look at the Americas, for example, it is the American Convention on Human Rights, which also affirms that the family is entitled to protection by society and the state. In Europe, similar provisions are contained, for instance, in Article 16 of the European Social Charter. The same goes for Africa, where the African Charter on Human and People's Rights likewise affirms that the family is the natural unit and basis of society, and further requires the state's parties to protect and assist this family unit. So the African Charter on the Rights and the Welfare of the Child also mirrors this language, and affirming, in addition, that the family shall enjoy the protection and support of the state for its establishment and development. So we see all of these rights throughout the entire system of human rights protection in international and also in regional human rights law. And of course, last but not least, the European Convention on Human Rights, which in its Article 8 states that everyone has the right to respect for his private and family life, his home and his correspondence, and so on, right? Now, if we look at what this right exactly contains, and it's very important to mention that the interpretation of this right, of course, has changed throughout the years. And especially in the past decade, the European Court of Human Rights has considerably extended the protective scope of Article 8. So the evolution recorded is inherent in the nature of this right or the nature of this provision, because Article 8 is the first of the Convention's qualified rights, whose main feature is that their application requires a balancing exercise or a balancing feat between the protection of human rights and, of course, the contracting state's margin of appreciation. Now, this is incredibly important when analyzing Article 8, especially from the perspective of our region, Central Europe, because the margin of appreciation can be quite extensive, and particularly when there is no European consensus, so to speak, on issues which have very deep-rooted social and cultural connotations, which therefore the state's parties have to be the ones who are the best to assess and respond to the needs of their own societies, right? So the margin of appreciation is a key concept in the convention, and it gives states discretion in questions of particular sensitivity. What is important, however, is that the margin of appreciation does not constitute a carte blanche to do as one wishes, right? It is not unlimited. As a common consensus emerges, particularly on issues of sensitivity or issues to which the law is in a transformative phase or a transitional stage, the margin will become narrower until it is no longer applicable or acceptable for a state to operate in a manner inconsistent with the European consensus, right, or the European practice. Now, the question is that when it comes to family life and the protection of family life, which is so inherently tied to the cultural norms and the values that are undeniably different in countries of Central Europe and countries of Western Europe or all over the world, right? We have to differentiate between these value systems. Will there ever be a consensus in these very sensitive matters or not? Now, Central and Eastern European countries share a common historical legacy due to which they are considered to have markedly different political and welfare cultures and value systems to those of Western democracies, right? So this different historical legacy has led these countries to a different system of values and priorities and a different interpretations of such key concepts as what is family itself or what is family life itself. So combined with the doctrine of dynamic interpretation, the margin of appreciation attempts to ensure that the substance of rights should reflect contemporary morality. But is contemporary morality in Hungary, Poland, Slovakia the same as contemporary morality in the Netherlands, Belgium, and the United Kingdom? I don't necessarily think so, right? Especially when it comes to matters of family. So what is the purpose of the rights under Article 8? The primary purpose is to protect the individual against arbitrary action by public authorities. And this purpose is achieved by shielding these four dimensions of personal autonomy of an individual, that is, private life, family life, home, and correspondence. And when we look at the structure of this article, we can see that it shares a structure with all of the Convention's qualified rights. The first paragraph states the content of the guarantee, whereas the derogation clause, which is in the second paragraph, sets forth the general conditions and the specific grounds a state party can invoke to restrict the operation of the rights and freedoms at stake, right? So while in most instances the court does not challenge the legitimacy of legal interference by the state into an individual's enjoyment of the right, it does require the state to prove that the measure which is being challenged is necessary in a democratic society because it meets a pressing social need or corresponds to some shared values. So the concept of necessity, of which proportionality is an ingredient, represents a battlefield in which these disputes are being fought between the individual and a state. So the perimeter of this battlefield has, however, been definitely changing, especially in this past decade, and it is influenced by the continuing social and economic developments of society. So the practical application of Article 8 has therefore become a very challenging exercise, because it is difficult to try and even predict its implementation in society, especially when it comes to socially controversial questions or situations of a very sensitive nature. And that is particularly true when we look at the gap between our understanding of family and family life and related issues between these countries. So in this respect, we could say that Article 8 is definitely one of the, or not one of the, probably the most open-ended article of the Convention. And over the years, it has proved itself to be able to cover a growing number of issues, and it is kind of a nursery for new emerging rights as well. It has extended its protection to a range of interests that would not fall under any other article of the Convention. Now, this is also due to the fact that the Strasbourg organs have not really provided any comprehensive definition of the interests protected in Article 8. We don't really have necessarily a comprehensive definition of what family is or what family life is, right? We can derive it, some of it from the case law, but because there is no set comprehensive definition, it makes this article fully adaptable to changing times. And we have seen that in recent years, that there have been attempts to extend Article 8's scope. Now, when it comes to the nature of family life, of course, when we are dealing with the family life component of Article 8, it is very important to understand the meaning of family. Now, the notion of family used by the court that was developed over the years or over the time is in line with the changing society, changing European society. And of course, it very well may continue to evolve throughout time due to our evolving social climate and standards. So the court has time and again confirmed that the notion of family life in Article 8 is not confined just solely to families based on marriage, and can also encompass de facto family relationships. So when deciding whether a relationship may be said to amount to family life or not, a number of factors are relevant that the court examines, including whether or not the couple lives together or not, the length of their relationship, and whether they have demonstrated their commitment to each other by having children together, for example. So the court has a flexible approach which takes into account a variety of family arrangements in the Council of Europe member states, as well as their current development or state of development. So we can say that under the Convention, de facto family life receives recognition on an equal basis with formally established ties. So we don't necessarily need to have a formally recognized marriage in order to have family life. The fact that the court decides on the existence of family life on a case-by-case basis by assessing the close personal ties that truly exist in this relationship, it means that it is not even possible to have a comprehensive definition or to even enumerate the number of various forms family life exists in. So in any case, if a situation falls short of falling under family life, it still may be protected under Article 8 under the realm or angle of private life. So what constitutes family life? In the European Court of Human Rights jurisprudence, the notion of family life is not confined, as we mentioned, just to formalized ties, but it also includes de facto family ties. So the following, as you can see, have been found to amount to family life for the purpose of Article 8. For example, a relationship between children and their grandparents, between siblings regardless of their age, between uncles or aunts and their nieces and nephews, between parents and children that are born into a second marriage or relationship or outside of the marriage in an adulterous relationship, right, between adoptive and foster parents. So family life truly is not something that we can necessarily confine into a very strict definition. Now, it is important to note that yes, social changes are happening, and that impacts how we are interpreting Article 8 as well. But social changes are not happening in the same manner in every single country. So this has to be a crucial point that we make. Article 8 cannot be interpreted as imposing an obligation on a state to recognize a certain type of marriage, for example, same-sex marriage, or establish a special regime for particular categories of unmarried couples for inheritance purposes and so on. So there are so many different facets and aspects of family life that we could touch on for example, touch on family life when it comes to adoption, when it comes to refugees, when it comes to asylum seekers, when it comes to traditional marriages or religious marriages, for example, all of these things that we could talk about when it comes to the protection of family life, which would be, of course, impossible to cover in such a short amount of time. But of course, as I mentioned, I have a little bit more of a comprehensive view in the written conference proceedings, which I hope that you will read. So in the recent years, the changing social attitudes and a broader understanding of what family is and what family life is, as well as the increasing mobility, the economic crisis, and so many factors have changed and affected family matters and the interpretation of Article 8 as well. But I think family still plays a crucial role in the upbringing of children, in providing the next generation, and ensuring social and personal development of its members. Therefore, it is very closely linked to cultural values and national tradition. So family is the foundational unit of society, and a society that does not protect its families is destined for ruin. And I think this is very important to remember. This is what we must remember when exploring the right to family life. Thank you so much for your attention.